Hello, everyone, and welcome to the program. This is Thunder Politics live on Channels Television. I'm Sean Kimbale, the Channels Television's global headquarters in Lagos, Nigeria. Tonight, the conversation is a matter of life and death. It is a resident doctor strike in the midst of a global pandemic and a threat of a third wave. The federal government and the doctors are not shifting ground, so we discuss further on this matter. Plus, also, we'll tell you about the debate over state creation in the ongoing constitutional amendment process. Stay with me, everyone. We'll give you perspectives right here on the program. But before we get into all of that, let me tell you that the People's Democratic Party, PDP, appears to be putting its house in order as the party has today reconciled the different power blocks in Anambra State after the governorship primaries, which caused some infighting, and the NWC has intervened, and the fallout of that primaries has caused some grievances within the some of the leaders of the party. Today, the PDP has declared and resolved that Senator Uche Ekunife will be the governorship campaign chair of the Valentine Ozigbo campaign.
All issues have been resolved, and the party is now in a good state and strengthened to take over Anambra State.
Let's get into our first conversation tonight. Earlier in the past week, the Association of Nigerian Resident Doctors embarked on an industrial strike action demanding that the federal government to make true to the agreement reached earlier this year. The doctors' strike is coming in the midst of the COVID-19 pandemic and the threat of a third wave. The federal government, as I ever said, the demands of the doctors are largely state government responsibilities. On Friday, we spoke with the Ministry of Labor and Employment, Dr. Chris Ngige, who said if the doctors don't call off the strike, the government will be forced to impose a work no pay regime and, in fact, take them to the industrial court if need be. The federal government appears ready to invoke the Section 43 of the Trade and Dispute Act of the Labor Act. Tonight, we have the president of the Resident Doctors Association, Dr. Yuilawa Okesuyi, who joins us from Asaba in Delta State, on some of the issues that have been thrown up by the federal government. Thank you so much, Dr. Okesuyi, for your time tonight on the program.
Thank you, Shil, for having me.
Let me start by asking you. You heard what the Minister of Labor said on Friday, right here on Politics Today. Perhaps I should remind our viewers who were not privy to that conversation and allow you to respond to what the minister said on the implication of your strike action. Take a listen to the Minister of Labor on the implications.
If you go to ILO principles at work, it guarantees a worker right to strike. But it has consequences. Your employer, on essential services in particular, has a right to replace you. He will also withdraw your money, your remuneration, and use it to pay those he has so acquired at those periods you were away. So, Nigeria, being a member of ILO, in our Trade Dispute Act 2004, Section 43, it is there to protect both the worker and the employer.
So all these instruments, you are going to put it into effect fully, 100%?
I will.
Okay, so now...
next week, I will escalate it because the conciliation has failed. So, and if the law says if conciliation fails, on my own side, I can move it up. Industrial Arbitration Panel or National Industrial Court of Nigeria. I've communicated it to that.
And what
they
does
will
that
not
mean?
receive money for the period on strike. And it will never count as a period for pensionable position in their career.
Is that a fair position?
That's what it is. Even the ILO supports it because they are on essential services. They're not supposed to go on strike without notifying me 15 days to that day of strike.
But
they
did
it.
So, Dr. Okesuyi, You heard what the minister said. Are you calling off the strike because that regime will begin tomorrow?
Thank you very much. I'm Dr. Wilawa Ohwaisi, President of Nigeria Association of Resident Doctors. And it's quite shameful when our political leaders in power and a doctor tries to now mix politics with medicine. You can be here now trying to justify your failures in making us know that in all the ultimatum was signed 117 days ago, you have failed in meeting our requirements, and you call off ILO when you have not even done the ones you're supposed to do. Is you not aware that we gave a notice of over 116 days? Was it not part of the people that signed the memorandum of action? When even then he came on air and bragged about it, telling us that he has said action, not memorandum of understanding, telling us that we make sure that the timeline given of 6 weeks to 8 weeks, that all these things would have been achieved before then. So it's quite shameful when an elder person that he act on no work. It was done before by the former minister Chuku and Adewale, and is what the legacy knows them for. So if you want to add to the group of punishing people when you have not done your own part, you cannot pick a child with a cane and at the same time hold the child's mouth not to talk.
All right. So let's take the issue one after the other so that our viewers can get an understanding, because your grievances will affect the average Nigerians one way or the other. So one after the other. Are you calling off the strike tomorrow?
We are not. We are resolute, and members of the Nigerian Association of Resident Doctors want to stay on this till we achieve something. Meaning that if we can change the narrative of the health sector.
So this strike is indefinite?
It's total and indefinite.
Total and
strike continues.
Okay, great. So yes. Tomorrow you are aware of the implication. The minister said it is a no work, no pay regime. Are you ready to face that consequence?
Well, we want to at least create a new narrative to all the threats. You can't be threatening somebody when you have not done your part. He refers to a court judgment that occurred in 2017 under Dr. John Iyebuchi and former Night President. The notice then was said that we did not give them proper notifications. The first notice of the strike was given on the 31st of January. On the 31st of March, we met them and told them about the strike and things we needed to do for our members. An addendum was added on the 9th of April. And on the 25th of June, we gave them a notification that we were going on a strike. So it was strange when he maybe, due to amnesia, he forgot that we gave them a notification that we were going on a strike on June 25th. Even after that, we gave them a notification 3 weeks ago that we have a meeting in Umuahia where he sent a representative to represent him. And after that, we communicated to him with an acknowledged letter telling him that these are the resolutions from the NEC. So now he cannot come to air to play to the media. I think we need to correct some narratives. The Minister of Health said that all the things we are fighting for are for states. But I think he has lost sense of what's really happening in the Ministry of Health. I'll give examples. The 114 members under the House officers are under the federal institutions, not state. The head of service brought out the paper telling us that they have been removed from the scheme of service. That was done by federal. And Lagos state government copied the same scheme of service and melted it down to our members. The members under the GIFIS platform, which are about 1,700 of them that have not been migrated into IPs. It's a federal problem, not state. The letter brought from the head of service stopping their capture into IPs. The federal something and not state. The minimum wage adjustment areas brought to our members was also federal and not state. The 2014, 2015, 2016 salary shortfalls are for federal and not state. The other allowance of 5,000 naira paid to all health workers, as compared to the hardship allowance of 1.2 million naira, is from federal and not state. The medical resident training fund that he said have been paid for 2020 and 2021, even when we know that Governor Buhari, the president of Nigeria, His Excellency Muhammad Buhari, just put pen to paper, acknowledge the sovereignty budget, and has not been even the money funding for it is not even available. So I don't know where he got his information from, and we cannot be bullied by him.
Okay,
he's not the first person to be a minister, and he won't be the last.
Okay, so let's clarify this also. You are in the essential services sector, which means that the life of people, when I was opening, I said, this is a matter of life and death. Because if you're not at work, people could die. And give us a sense of what you make of some of those who say, could strike be the last option? Is this the last option that you have? Must you go on strike considering the situation the country is in? And the minister said it on Friday, that at every opportunity that you had, you just want to go on strike. Considering the fact that lives of people are involved, must you resort to strike actions?
Thank you so much, sir. We all know that even when the Sun was on your channel some days back, he said the essential services had electricity, military, and the police. But due to the public health rules, we are acknowledged as part of the essential services, which we agree. We have had recurrent strikes based on recurrent failures of the Ministry of Health. What we're asking for now is what I've been asking since a decade. The hazard allowance was last reviewed in 1991, and non-narrative have been done about that. The Medical Resident Training Fund was acceded to in 2017 and was put to law, not 2021. The minimum wage was last done last year, 2020, and not yesterday. The 2014, 2015, and 2016 were self-explanatory, means they were done 7 years ago. If you fail to try and solve the primary problem, you can't at the middle of the game want to change your position. Have they asked themselves why they have failed to acknowledge the MOA signed with them? He posted on TV that I lack knowledge of knowing the labor laws that tells you that an MOT, a MOT and a memorandum of understanding is different from a memorandum of action. And you put a time frame to it. And those involved in trying to make it work have failed. The question Nigerians should ask them is, what have they done to those that have failed? If you remember back in the 1950s, we are aware that UCH Ibadan was one of the premier hospitals in Nigeria, where even people from Saudi Arabia, London, come to seek treatment in Nigeria. As it stands, we're just a ghost of ourselves, being the greatest of Africa. There's no zone in Nigeria, as it speaks, where you can get a functional hospital that is world class. If we had one, they wouldn't go abroad when they had malaria or headaches to seek for medical care. It's a shame, and I need to ask the government and the Nigerian populace to ask them questions. In different clients, when you do not know the services to render, you should resign honorably and hide yourself in shame. Not come to the media and fill them with lies and think you get all over it because you're a politician. And he has forgotten that he's a doctor.
So, no, let's now...
That's where we find ourselves now.
The last time you went to the National Assembly, and it does look like there were some positives that came out of the meeting which you had with the Speaker. Are you doing the same this time around? Because things seem to have gotten to a head.
We got an invite from Dr. Tanko Sununu, the committee chairman on health, for tomorrow, 11 a.m. And we have told all members that we'll have a meeting with them. There, of the Speaker of the House, Honorable Femi Baji Amela, through his magnanimity again, has invited us to try and sort it out. But I think we need to talk about the recklessness of those in politics. You cannot, out of self-interest, say, I would not want to negotiate with them or call them for any meeting. Nobody has a right or play God over 16,000 resident doctors. You cannot tell us that you are so naive and so outdated that you do not know that you cannot call doctors to take over people that have been in residency training, wanting to be consultants. So you want to shift and bring them in to take over their positions. You know that there's a big lacuna when there's a brainstorm, and virtually all health workers are leaving Nigeria to better shores where they can get good security, good insurance policies, good places to work, good infrastructures to work within the hospitals. I want to ask him a question, him and the Minister of Health. When last do we have any place in Nigeria where you have functional MRIs, CT scans, radiotherapy, when it's on the private-public collaboration? Those are things they should ask.
All right.
When the health industry is going down, when they are...
I wanted to ask you another question, because the minister talked about the issue of notice, that by law you are to give notice. Although we have a document you're showing that states that you gave notice, but I'll allow you to listen to the minister and directly respond to what is said in the case of the notice of the strike action. Take a listen to the Minister of Labour on that.
You finish conciliation with me, shake hands with your employers, and thank everybody, and we thank you. And you now go to your next meeting. You allow those doctors from the states to overwhelm you. And then you pass a vote of going on strike 7 days after a meeting. The same thing they did after meeting with me on 31st of March. They went on strike on 1st April. And later on came back to now start dotting some things they say they don't like as an addendum. And we produce that addendum on the 7th. By the time we are producing this addendum, they have been on strike for 10 to 12 days. And people who are not well to do, to pay for private treatment, who rely on public hospitals, a lot of them have died.
All right, that is the response of from the minister when I asked him on the issue of notice. But it said that if you do not return to work, that there are locum doctors that might take over your jobs. I'd like you to respond to the issue of notice and locum doctors taking over your jobs.
Thank you very much, Cheryl. That's why I say you don't meet politics with medicine. Yes, he boasts on all media that he's a doctor and he knows virtually what happens and how it's run. But you should also know that when you are trying to be a specialist, means you have left your internship, you now write primary, you go for NYC, you write primaries first to want to go to any specialty you want to train in. It takes at least an average of 3 to 4 years to become a senior registrar. And take at least 3 to 4 years also to become a consultant. So it would be shameful when a senior colleague like him tells you on public media that you are going to replace those under specialties with a locum doctor. Means he does not mean well for Nigerians. It's quite shameful also when he comes to media and tell you that we have abandoned people. When last was the salary stopped? When he travels around the country, is not paid DTAs? When last did he suffer what those that have not been paid for 19 months? Is he not able to pay his children's school fees and put a roof all over their head? Those that have not been paid for 19 months, 8 months, 6 months, have you ever wondered how they have survived when their children are sent back from school because the doctor cannot meet up to pay their school fees? Have you ever tried to reason when you cannot give your children food to eat because you have not been paid salaries. It's quite a shame on people in government,
You know,
when they do not do the right thing.
Dr. Okesui, I want us to stay on the issue and not on the personalities, so that we can, because he's speaking on behalf of the federal government. He's talking for the federal government. I'm not sure he's talking in a personal capacity. But did you give notice? There is this document I'd like to show our viewers, that is that what notice that you said you gave to the federal government? Go ahead. Is this the notice you're talking about?
We have given government notice for over 10 times, with acknowledged stamped copies from Ministry of Health, Ministry of Labor, Ministry of Finance, the SGF office, the IP's office, the Attorney General's office, and every other part we have given. So it's strange when you know that documents can be produced, and you come to public domain and lie. Even when the time we met him on the 25th of July, trying to tell him that we had issues with the oncoming next meeting, and we need to tell our members where we are. And it's obvious that acknowledged copies of that has been in his purview.
But
so he may not have.
Yeah, doctor, this notice that you sent, the notification, was the outcome of your NEC meeting, or your virtual emergency NEC meeting, and which the minister argued or debated or dispelled that this is not a notice. This is just the outcome. If my producer can put that back so that our viewers can see it, it was stamped on the 25th, 28th. The 25th, that's when it was dated. That's exactly the address to the Minister of Labor and Employment, the notification of the outcome of your virtual emergency National Executive Council meeting. The minister said on Friday that this, by law, is not a notice of strike. This is just an information about your meeting, which is not a legal binding when you talk about trade dispute. I'd like you to respond to that.
Thank you very much, Sean. We have given several notices to them, acknowledged copies. We gave one on the 25th of June, gave one 3 weeks before the meeting, gave the ultimatum that we went on suspending the strike, based on the on the 31st of January, 31st of March, and on the 9th of April. But after that, we have given virtually like 8 notices to them. That is why he actually called us and invited us for the meeting that occurred on the 25th of July. So I don't know what else he wants us to do. Even on the 2nd of August 2021, we actually told him about the outcome and resolutions made at the meeting, and we told him that the NEC unanimously said we went back on the strike on 8 a.m. 2nd of July. So it's quite strange when you come and deny every other thing. But sir, the main thing we need to do is this. Have we asked why those ultimatums given to them have not been answered? Nigerians need to hear why they have not acknowledged that they have failed in the MOA signed with them.
The federal government said they said they have met it. Maybe I should allow you to listen to the minister on that. One of the demands that you made, the federal government said he has attended to it, but in fact, it was the error or the lapse is from your own side. Take a listen to the minister on the issue of the medical training fund.
2020, it was paid. And even in payment of 2020, the resident doctors injected names of people who are not qualified to receive the money. They also, we have some of their members who have finished residency program, left, that were also paid because they supplied the names.
But if
now, some of their members now didn't get, because those who are not fit and proper persons to get this money have taken the money. They pledged, the resident doctors pledged, that they will get those people to do the refund. You know, government and how it works. You have not expended that 2020 well. 2021 is captured in the service-wide vote because it's one of their problems that they say they have. Budget Office of the Federation tendered evidence that is in 2021,
All right.
supplementary.
Yeah, so
under service-wide vote. So once they reconcile the 2020 utilization, expenditure, because government insists on retirement of money given to you.
that is the explanation of the minister. How do you react to that?
I'll start with one thing. One, we are medical doctors, not secretaries. That means we are not in charge of a list meant for payments of the Medical Resident Training Fund. There's a body that regulates medical resident training, which is the National Postgraduate College. The list for payment for Medical Resident Training Fund is brought by the National Postgraduate College, who are in charge of training of residents. That's one. Two, the list is submitted to the Federal Ministry of Health, who vets the list and send it to the IP's, the Attorney General's office and the IP's office to sign. So I don't know why it's involving a resident doctor who's in training saying to his patient that we brought the list.
So
they don't know how the list came. It's shameful.
On a final note, Dr. Okesui, the tomorrow is just a few hours away. You're going to have that meeting. Are you going with an open mind that maybe the National Assembly members can intervene because the federal government looks set to implement the no work, no pay regime, which begins tomorrow? What is your next line of action?
Yeah, we're going with an open mind in trying to help Nigerians that are ill, that need treatment from us on how we can, in the short time, see that them. But I insist residents would not into work. If he wants to toe the line of no work, no pay, I think he needs to go and look for 16,000 residents, doctors, to occupy our place. But I also want to ask Nigerians to ask them and tell them that those that are the cause of the strike that have not done their work should either resign or be sacked from the positions they hold. Because if you cannot deliver, you don't have no responsibility.
And who are these people?
There.
Who are these people?
The Minister of Health, the Minister of Labor, the MDCN registrar, Sanusi. They are the ones to be held responsible for the strike we are on. And something needs to be done to them. If they can do that to them, they can implement the no work, no pay. We'll take it that way. In equity, you come with clean hands.
Okay. We look forward to what happens tomorrow after your meeting. And we do hope that there will be a meeting point where all of these rancor is resolved amicably. Dr. Uyilawa Okesui, the president of the Nigerian Association of Resident Doctors, thank you so much, and I wish you and your colleagues the very best.
Thank you for having me, and a good night to everyone.
Thank you. Up next, everyone, we'll take a breather and a commercial break. Senator Ajibola Basiru, the Senate spokesperson, joins me on the program, and it will be talking to us on the state creation debate, the constitutional amendment, and perhaps on some matters of the APC internal affairs. Join us again, everyone. Welcome back to the program, everyone. The National Assembly is in the process of collating and making sense of the proposals made towards the amendment of the Nigerian Constitution after the public hearings that was held across the country a few weeks ago. But the Senate has come out to debunk reports that the lawmakers have proposed the creation of 20 more states, saying that the upper chamber was grossly misrepresented. State creation is part of the proposals made by different persons at the different centers across the nation when the public hearings held. take a look at some of the states proposed from Ibadan State, Tai State, Katogum State, and also propositions to make the FCT state also, Okura State, Adada State, Gurara State, Ijebu State, Ibadan State. The list goes on and on and on of some of the propositions. We presently have 36 states and the FCT. So if any of these propositions are included in the amendment of the Constitution, how many states are we going to come to? Well, let's talk about what the real position is. The Senate spokesperson, Senator Ajibola Basiro, joins us from our Abuja studio to clarify some of these issues for us. He's also a member of the Constitution Amendment Committee. Thank you so much, distinguished Senator, for joining us tonight. Give us a sense of what, because in your statement today, you said it's not as if you're creating a state, but it's part of the proposals and the propositions. But how strong is the proposition to create more states in Nigeria?
Yeah, thank you, Sheun, for giving us the opportunity to make that very important clarification. When I woke up to a screaming headline on one of the national daily that Senate proposes creation of 20 states and made reference to INEC, I was shocked because that never occurred at the recent retreat of the Senate that was held over a 3-day period and which I participated. The issue of state creation is not just about constitutional amendment. You will know that the provision for amendment of Constitution generally is provided in Section 9 of the Constitution 1999 as amended, but specific peculiar provisions are provided for creation of state and local government in Section 8. So, situation we have on hand is that we must make a distinction between Section 9 amendment and Section 8 amendment. Even Section 9 amendment is in twofold. When the amendment relates to Chapter 4, which as it is about fundamental rights of the Constitution, you will require 4/5 vote of the National Assembly in the two chambers, but any other amendment will require 2/3. In relation to creation of the of new states, Section 8 envisages 4 very important positions to occur concurrently for us to even be talking about a bill before the National Assembly being competent to be considered for state creation. And that was the essence of the clarification I had to make. First and foremost, the Senate is not making proposition for creation of any state, whether 1, whether 2, whether 20, or whether any number. What has happened was that there were requests for creation of states, and the Senate is not in a position to even make that proposition until requisite provisions of Section 8 are complied. And what are these provisions? 1, the request for creation of state must be supported by 2/3 of elected representatives in the two chambers of the National Assembly and the House of Assembly from the areas from which the state is to be created. Secondly, the request must be supported by 2/3 referendum of people in the area from which the state is to be carved out. At the same time, even after the referendum, the people in that area must also agree. Then you are also talking of 2/3 resolution of the two chambers of the National Assembly. So before you even talk about National Assembly considering whether to give assent to creation of state, the first requirement of the request being supported by 2/3 of elected people within the confine from which the state has to be created need to be passed. I'm not sure that threshold has even been passed. Assuming that threshold has even been passed, the INEC has a role to play, and that is in conducting referendum, and the referendum must be supported by 2/3 of the people within the area that has been created. And if the way the Section 8 is drafted, 2/3 appear to be general, not those who have actually participated in that process. So as far as we are concerned, the Constitutional Amendment Committee of the Senate has not made proposition for creation of any state. We have only made reference to INEC to go and consider whether there have been proper case for us to even begin to talk of a consideration of creation of a state. So that clarification is very necessary, because at the issue of state creation, we'll have to look within the parameter of even the challenge and efficiency of a governance structure in Nigeria. There are schools of thought that even thought the IC state structure is even too large, but without prejudice to the fact that Nigerian constitution creates facilitative provisions in Section 8. As a National Assembly, we cannot deny people from making the request, but that request must pass the necessary threshold, procedure, and lay down rules in Section 8 of the Constitution.
If you look at the last time the creation of state was done in Nigeria was around 1996 or 1997, when we got to the 36 states. 1991, it was about 30 states. And 1987, I think that's when we were 21 states. In 1976, we had about 12 or so states. And 1963, it was just about 3 regions of the country. In 1960, it was the northern, the eastern region, and the western region. And we have come to this point. I was at some of those hearings when some groups, I heard the one from Ibadan for the creation of Ibadan State. I heard the one from Ogun State, where there was a motion to create an Ijebu State. But these are, if you listen to these people who brought about these motions and these propositions, they have genuine interest and genuine reasons for wanting these states to be created. But at the retreat that you had, a 3-day retreat, when this matter came up, how did it go?
At the retreat, you see, there's a difference between people having genuine concern, that's those who are the promoters of those states. There's a difference between whatever their motive is and whether they have complied with the provision of the Constitution. The Senate committee availed itself of services of legal scholars, political scientists, and economists in discharging responsibility. And at the retreat, all these consultants engaged by the Senate actually also participated actively. When it comes to the point of the issue of state creation, simple question. What is the procedure? Section 8 of the Constitution was looked at, and as far as we are concerned, the position of the committee is that we cannot even proceed because we have not seen evidence of a request supported by 2/3 of the legislators within the confines of state requested to be created. Evidence of that was not before us at that time. We have also not seen evidence of support of 2/3 referendum affirmative to the creation of those states. So with those two prerequisite, mandatory prerequisite in Section 8 of the Constitution, the Senate committee merely deferred the matter that we cannot begin to consider that until we are satisfied as to the evidence of those requirements. This is not to say that one is either in agreement or disagreement of those who are the promoters, but we are sworn to uphold the Constitution. Section 1, subsection 3 of the 1999 Constitution are comprised of the provision of inconsistency. Any act or law inconsistent with the provision of the Constitution shall, to the extent of the inconsistency, be null and void. So we cannot begin to talk as a National Assembly that want to create a state when the requisite mandatory provision of Section 8 up to the level that it will even properly come before us has not been complied with.
There was an agenda before the Constitutional Amendment Committee when you started off in this 9th Assembly on the issue of constitutional amendment. Was state creation part of that agenda?
Of course, when we talk of creation, amendment of Constitution, it's not just National Assembly that will set the agenda for it. And that's why, as a body, we will receive memoranda from different parts of the country, from different sector, different age group. We also have senators who are interested in making certain aspects of our constitution to be reformed, and they introduce bill. Personally, I also have cause to introduce some bill on constitutional amendment. Of course, the public hearing and the opportunity to throw in a memoranda before us also came up with some requests for state creation. But the question is that it's not just enough for there to be a demand for creation of state or insertion of certain reform in the constitution. The requisite provision of the constitution must be complied with. I said, for instance, if there is a proposition to amend a section relating to fundamental rights in our constitution, it must comply with the requirement of section 9, which require 4/5 of the vote of the members of the National Assembly, aside the 2/3 of the Houses of Assembly to say true. This is a special provision to safeguard that provision on fundamental rights is not amended whimsically. The same thing with creation. I will say that even though new states were created, most states that have been created in the history of Nigeria were done during military. From the provision and my reading and understanding of Section 8, it will be an Herculean task for a democratic government to be able to create a state. I would say it is not impossible, but I say the threshold is so high and very cumbersome that it may well be very difficult for the National Assembly and even the INEC to be able to certify that the requirements of Section 8 have been complied with.
That referendum part is going to be a big deal, and like you mentioned. But let's look at the constitutional amendment process. And you've explained to us how difficult it might be for creation of state. Not to say that those who have made efforts shouldn't be hopeful for the propositions they've made. We are in a nation where people can dream, and as such, people can aspire. But give us an understanding about what the process currently looks like. Nigerians are hopeful that if the constitution is fixed, we might have a better nation. But how far with the constitutional amendment process? Are we sure that before the end of this 9th National Assembly, we might have a fixed or an amended constitution?
It's not even going to be the end of the 9th Assembly. I'm very optimistic. By the end of this year, the processes for amendment of the 1999 Constitution would have been concluded. And I say it with all understanding of being actively involved in the process. I'm a member of the Constitutional Review Committee. I represent my state, State of Osun, on that committee. And of course, I've also part of the team set up by Southwest Governors Forum to interface with the National Assembly to ensure that a meaningful resolutions come from the exercise. And this retreat that we just concluded this Friday is the second of such retreat that we have had in the past 1 month or so. And notwithstanding that we are currently on recess, we are still going to have another retreat before we resume back. We hope that as early as September or early October, we'll be able to lay a report before the National Assembly. Currently, as at the past 2 retreats, we have considered harmonized bills of the House of Representatives and the Senate, and these bills are quite about 155 or so, in number, and they go through different areas that I believe, if we are able to get the requisite votes at the floor of the National Assembly and the 2/3 in the Houses of Assembly, will be able to make some meaningful injection of relevant provisions that will help in developing governance, also help us in achieving the goal of advancing the welfare and security of our people. I can make allusion to some of the areas that we have looked at and that we appear to have some consensus. In the area of local government, we have come to a position that there's a need to have a constitutional guarantee of a term of 4 years for our local government under a democratic system, and that any local government that is not democratic will not be able to draw allocation from the federal government. This is to ensure that the regime of caretaker arrangement in local government will be done with. Also, the question of funding of local government has also been looked at, and relevant provision to ensure, their funding both by the federal and the state government, and insulate dissipation of their funding has also been inserted in the proposed amendment of the Constitution. Of course, the issue of judicial autonomy and apportionment of resources, to them from allocations, to the state, it has also been looked at, and the distribution of resources under Section 162 has also been amended in this regard. In terms of devolution of power, some items on the exclusive legislative list are now going to be on concurrent list, and even in the context of being on concurrent list, they will be bifurcated into area of exclusive legislative competence of the federal government and state government. For instance, if the amendment say true, in terms of incorporation of companies, companies that are operating within the confine of a state will only need to be incorporated under the state law. Whereas if it's a national company, then it will be under the national law. Registration of business name will be the business of the state, and of course stamp duties in relation to those state companies and businesses will also come in respect of the appropriate authorities. And we believe that this will free some resources for the state and allow fiscal federalism. So we are looking critically at the exclusive legislative list with a view to bringing some of the items down so that the state will be able to work. And of course, one of the turning issues we are looking at is issue of creation of state police or decentralization of the Nigerian police to address the question of unbundling the security architecture of the country. Even though we don't have a landing yet on this issue of state police, but I believe that there are certain advancements in discussion and getting consensus around creating an efficient and a devolved police force for the country. Of course, other area has to do with issue of magistracy and ensuring that they accorded the recognition as judicial officers in the Constitution, because we believe that the bulk of criminal adjudication is done at that level of the judiciary.
On a final note, I'll take you away from the constitutional amendment. Just in the last 1 minute that we have for this conversation, you have a PhD in law, so I always recognize that to get your view on some very turning legal matter. Your party, in the wake of the Ondo State judgment, the Supreme Court judgment, there's been a lot of debates on the leadership of your party and the future. And the World Congress you went into, it does look like it's a difficult time for your party. What's your opinion and your view on what is happening in your party? Just a minute before we go.
We must make a distinction between informed opinion and opinion that is jaundiced or prejudiced by lack of understanding. I've had opportunity of reading the judgment of the majority of the Supreme Court, and I believe they decisively dealt with some of the issues that some commentators are still commenting on. It appeared that some commentators, even though members of our party, are self-seeking in their opinion, and they were not actually seized of the totality of the reasoning and rationale of the Supreme Court decision. And to just briefly summarize what the Supreme Court has said, Supreme Court said the position of the caretaker committee is an interim position, and it does not come within executive position or position deriving pecuniary benefit within the contemplation of Section 183 of the Supreme Court. So as far as they are concerned, Governor Buni and of course my governor, Governor Itola, who is a sitting governor and a member of caretaker committee, have not violated Section 183. And the Supreme Court went further to say that the issue of nomination is not done at the National Secretariat. It's done by people at the Congress of the party. And there was no contention, no argument, and no appeal as to the fact that Governor Akeredolu was emerged as the candidate of our party at the primary solemnly conducted. So the question of whether somebody signed letter in what capacity or the other was considered to be immaterial to the question of validity of nomination. In fact, the Supreme Court went further to say that the requirement for qualification and disqualification of candidates are constitutional, and to the extent that constitutional provisions have been met, there's no basis for anybody to challenge and to succeed in that challenge in that regard. And this is in line with established position of Supreme Court in earlier cases like INEC and Musa, that when Constitution has provided for a position, a proposition, any other contrary provision will be inconsistent. Even a repetition of similar provision of the Constitution will be considered inconsistent as to the extent of superfluity. So I believe our party is on a firm ground, and that the commentators are saying otherwise are not informed.
Senator Ajibalola Basiru, the Senate spokesperson, thank you so much for your time tonight. I appreciate it.
I'm happy to be here too. Thank you, Sheung.
Thank you. Just before we go, everyone, many Nigerians are angry and agitated about the state of the nation and so many things that are not working, especially on what the government did not do or what it did and not do well. And there are enough blames to go around. Nigerians want a great country that works for them. And as citizens, we all deserve a nation that works, not for a few, but for all. It is the right to hold government and leaders accountable. But you know what? There is one they call civic responsibility. That is a part where the citizen play its own role in building the nation. That includes deciding on who governs or electing those in position of authority. That is the role of you, the citizen. The only way to do that is through elections. And the only way to be able to vote in an election is if you register as a voter. Elections are not won on social media. They are won really and truly on the ground, on the field, through the ballot. And guess what? The statistics tells us those who are most influential in the scheme of things, more than half of all voters, 51.1%, are between the age of 18 and 35. According to INEC, but most of votes, that number, sit at home on election day. Only 44% of the 85 million registered voters turned up at a polling unit in 2019 to vote. If you want to change anything, you have to be active, and to be active is to be registered as a voter and also vote on election day. The window is here now. INEC's continuous voter registration exercise is ongoing. Elections are not won on social media, like I said. Your vote is your power. As a young person, use it wisely. And that is my final word tonight. Many thanks, everyone, for watching. I'm Sean Okimbaloye. Enjoy the rest of your evening.